report on the substance of the committee meeting held yesterday, February 3rd, 2012 in Las Vegas to obtain public comment on a draft regulation governing the trapping of fur-bearing mammals in residential areas of the county whose population is 100,000 or more per the 2011 legislative session, requiring the Nevada Board of Wildlife Commissioners to adopt regulations by December 31, 2012. Based on the report, the Trapping Regulation Committee shall consider revisions and additions to a draft regulation. Commissioner McNinch.
Well, thank you. Everybody, I suspect, knows that we had a meeting last night, a committee meeting, where a proposed draft regulation was presented to the public for comment in Southern Nevada and for presentation here at the Commission today. I'm going to enlist Rob as we go along here to help with some of the justifications, but the bottom line is that pursuant to the direction of the subcommittee and with the guidance from the Commission at our last meetings, we were tasked with coming back with the proposal addressing specific items. In an effort to place our focus on the committee found itself, it's been difficult to stay within what we believe to be the interpretation or the intent of SB 226, which is driving the development of this regulation. And as part of that process, there's a wide variety of opinions on what we're supposed to cover, what we're not supposed to cover, et cetera, et cetera. With the meeting in Reno and the meeting in Las Vegas, the committee meetings, we developed a list of items that we felt were of concern from the public. We came back and we included those portions that we believed were aimed at dealing and satisfying the intent of 226, with the understanding that not knowing for sure if it was going far enough. I guess I'll put it that way. Okay, we're left with interpretations. We're left with our what we believe. There were two items in particular that we sought guidance from the Deputy Attorney General, assigned to the Commission up in Reno, and that had to do with the 96-hour visitation issue and the trapper ID/registration issues. I did receive correspondence back from the Deputy Attorney General, and I'm sorry, I'll find that very quickly here. And we were advised that we had, that based on the language provided in the ID registration, it had been changed from shall to may, that the language was considered permissive, and that we had no authority to deal with the registration issue as part of this process, and to carry that out one step further, nor would the Commission. Okay? It's a legislative issue. Having said that, the visitation issue was a little different story, and I'm sorry I can't find my notes. All I'd live as best I can. The guidance was that that the visitation issue, we were not precluded from addressing that issue as part of this process. But she did provide us with guidance, some thoughts, perhaps stopping just short of a recommendation, but certainly some guidance. That if we were to get into the visitation issue, it would be very complicated, that it would be fairly focused in very small portion of the intent of what they believe. She felt that we had the opportunity to deal with it, that it might be better off to deal with it as we move forward through this process. So the visitation issue is not something that the committee addressed specifically. Okay, it's in the parking lot for now. Okay. There would be issues with LCB, apparently, pursuant to the review. We do have some timelines that we have to be cognizant of, and that some of the visitation stuff could cause some communication back and forth with LCB that would put us in jeopardy of not meeting our statutory mandate of dealing with these particular issues. So it hasn't been forgotten. It's not been set aside. It's not been ignored. There's a reason why it hasn't been included, and it was pursuant to the guidance we received from our DAG. Okay. Specific to, I'm going to point out some things that were brought up last night before I go over the regulations so that you kind of know, you can see where some of the discussion occurred. There was a comment, and it is the only action that the committee did take to direct staff, and it had to do with defining. If you look under one, I need glasses. 1B, thank you. I'm sorry? No, I'll be all right. I'm probably more just tired, like a little sissy, I guess. It had to do with the defining or differentiating between the terms depredation or control purposes. Okay? To a lot of us that have been part of these processes and maybe a little more familiar with the terminology, it was kind of natural to just roll with it because I think we understood the intent, but it's not clear. So we've asked staff to go back and provide some clarification on what is meant by control purpose and what is meant by depredation. They're two separate issues, and so we've asked them to do that. So that'll be something that comes back sooner than later, or in the future meetings here. A lot of the discussion focused on. There were a lot of comments on a lot of different issues, but really the 1,000 feet, 1,000 yards is definitely an issue. It's definitely a major part of the discussion. Yet there were, folks are polarized. There was a suggestion to incorporate instead of 1,000 yards, a half mile in the name of making it something that people can relate to better. A little more, something that we're a little more used to. And as I said last night, for those of you who don't know, in comparison to 1,000 yards, a half mile is 880 yards. So put it in perspective a little bit. There was a lot of discussion, there's some discussion on Red Rock, the conservation area associated with Red Rock, okay, and how the laws and prohibitions and trapping allowances relate to this regulation. I believe that we do need to do a little more work in that area just to make sure that we fully understand what's going on with regards to Red Rock. And the most significant issue that I believe is still going to need to be addressed at some point here has to do with the use of trails down in the southern Nevada area, particularly the Mount Charleston area. There was a lot of comment. I have to admit, we recognize that 2 million is a lot of people. Unless we live down here, maybe we don't have quite the understanding of how much use some of these areas do get. It is their backyard. It is a relatively small area for lots and lots and thousands of people to go to. So there were a lot of comments related to addressing trapping in association with trails and roads and things of that nature, particularly on the Mount Charleston area. Rob, do I need to cover anything else, committee members, real quick, just as a broad overview before we move into the reg? Okay, all right. We felt as we went through, Rob and I sat down and put together this proposed reg, primarily Rob. We believe that we considered the comments that we received in the Reno meeting and the Las Vegas meeting, the committee meetings in particular. We felt that we had considered the comments and the issues that each person addressed and have a reasonable thought process for why we did what we did, okay, why we proposed. It doesn't necessarily reflect in the small boxes off to the side. Those are little succinct notations to try to provide some idea into our thought process. So it may be that we have to discuss a little more in depth what some of the actual conversations that we had to get to that point. So Section 1, Chapter 503 of NAC is hereby amended by adding thereto Section 2, inclusive of this regulation, to read as follows. No problems there. Pretty standard language. Section 2, except as otherwise provided in this section, it is unlawful for a person to set a trap other than a box or cage trap within 1,000 yards of a residence within the borders of Clark County or Washoe County. Okay. You notice the term residence. I believe that there were, the previous proposals had included verbiage related to occupied dwellings. This was our intent to try to standardize and try to come in line with the residential area concept, which in line is kind of discusses the congested area / firearm issue. We had to try to come to some decision on what exactly are we going to pursue here. We're going to go with the residential. We're going to go with congested. The decision was made to come out of the box with residential language related to residential areas and residences. So that's hence the term residence. And 1,000 yards is largely going to be a to improve safety between 1,000 feet, 1,000 yards, 800 yards, 999 feet, 1,001 yards. You kind of get the point here is that we're dealing with managing some perception. Let's be real honest about it. We could debate public safety until we're blue in the face, and this is going to be one of those decisions that is how conservative do we want to be, to what extent. I think that personally, I don't see where 1,000 yards or a half mile, whatever way we decide to go, is really that significant. I don't know that it's in the world. So. The provisions of this section, so Section 2, Subsection 1, the provisions of this section do not apply to. So we have to, we heard from the pest control industry, other agencies that are concerned about fulfilling the missions of their agencies. So we tried to incorporate a handful of exemptions. The provisions of this section do not apply to an employee of the department acting in an official capacity, a person trapping under the authority of a permit issued by a government agency that specifically authorizes the take of unprotected wildlife for fur-bearing mammals or depredation or control purposes. So there's a lot in there. Okay, so we're dealing with making sure that the agencies that are responsible for maybe some public health protection issues, maybe some protection of levees, for example, that might be out there. We do have ditches that run through the Reno area that there are potential for. We've seen it in Fernley for those to be damaged, and it addresses the concept of the exterminators, the pest control operators. All these folks must be permitted in some fashion. So the intent here is to make sure that they're able to do their jobs. They're overseen by agencies. They're within the system. They're in the system already, and to recognize that they have important work to do as well. C, a person trapping on private property. Generally speaking, I think we all recognize that people, private property. People have a right to protect their private property in an appropriate manner. So this was, in a sense, trying to recognize that people that have private property, forcing's not being trapped on people, forced on people with private property, and therefore private property operators would have the ability to trap on their private property if they so choose. There was a suggestion that would include to allow somebody else that would be trapping on private property an allowance for that, but there was no recommendation, and there was nothing that came out of the committee regarding that. Personally, I think that's a real slippery slope. It creates a lot of problems, a lot of issues, and I would very much prefer to just see the exemption for somebody on their private property. D, a person trapping in a waterway outside city limits. Okay, this one gets a little more difficult to understand, but the intent here is that we're addressing a waterway specifically, which we relate to it a little bit better in the northern Nevada area, because we do have streams and creeks and rivers that run a little more year-round. But the intent here is that if you're trapping inside the city limit, this exemption would not apply. Okay, you would be subject to the the provisions of the 1,000-yard setback from a residence, okay? If you're outside of the city limits, Rob, so far so good, okay? If you're outside of the city limits, you would be able to trap within that, the 1,000 yards, you would be exempted, I'm sorry, person trapping in a waterway outside city limits. If you're outside of those city limits, you would not be subjected to the 1,000 yards of a residence. Hard concept. We might have questions, but okay. Section 2A. As used in this section, A, box or cage trap means any device designed to contain or confine an animal within a box or cage. Any device designed, built, or made to close upon any portion of an animal shall not be considered a box or cage trap. That's been pretty standard language. It hasn't changed. People seem to be generally comfortable with that. B, residence. So rather than defining occupied dwelling, we're going to define residence. Residence means any house, room, apartment, tenement, or other building designed and intended for occupancy as a residence. So what we've done is by building this definition of residence, we're getting away from the concept of the congested area, the discussion on the firearms discharge areas, and we're expanding it out to residences. So this regulation would not apply just to houses in a residential area. As inside of a city limit, it would apply to individual houses as you go out. Okay, so in the remote areas of Clark County and Washoe County, this the 1,000-yard setback from a residence would apply. Okay, and that's an important concept to keep in mind. Okay, C, definition of a county. County with a population of 100,000 or more means Washoe County and Clark County. Rather than specifically identifying, rather than placing into the regulation Clark County or Washoe County, it was important to define what a county with a population of 100,000 or more is. That would not preclude or prevent or disallow adding additional counties if we hit that 100,000 population mark. It takes the subjectiveness out of how it's applied when that occurs. Does it occur now? So as we go along, if somebody's trapping in Elko County and they get a little cross, Elko County comes up over 100,000, how's that to be defined? Who's right, who's wrong? 100,000 to based on some stats, and 100,000, 99,000 based on others. It would be recognized in this regulation right here, and it would probably be based off some census data or something that's more official based on the way that it's conducted in statutory and code language now. So we're trying to be consistent with that thought process. Waterway means any river, stream, canal, or channel that contains water. So I don't know if there are probably some questions of the committee, and the board, and I don't know. I'll let you take it from here if you want to go proceed.
Okay, anybody on the commission have any questions with regard to the regulation? Anybody? Okay.
Before we move on, Rob, is there anything else that would be pertinent to throw out at this point in time? There's a lot going on with it.
Okay, so are we ready for public comment? Okay. Go ahead and put it out to the public, and Vice Chairman Gina Barnes.
Gina?
Get first.
Now am I limited in what I can say?
With regard to the regulation?
Is it just the, because I still haven't gotten the, by the way, for the record, Gina Grice and Nevada Voters for Animals. I want to say first, I know it's been a really long day, and we've waited just like you have, and we appreciate, I know Chairman Macbeth, you've been at all these meetings this past week, right along with us, so we definitely appreciate that you care enough to be present and get all the input, and everybody else that's been there too, and all the time that the chairman of the Trapping Regulation Committee has spent doing this. We appreciate. I'm still confused about whether or not, and I know that we're talking about, we've limited it down to residences, but since there are residences up on Mount Charleston within these federal lands, and that I believe like Blue Diamond and there's other residences that may be within the Red Rock Canyon National Conservation Area, I guess I would say that in Section 2, I would like some sort of language that would say, like, except as otherwise provided in this section, is unlawful for a person to set a trap in violation of applicable state and federal laws on public lands other than a box trap or something. You know what I mean? Somehow add that in there so that we've addressed this issue of residences that are in these other areas that have their own sets of rules. Because it's not, you know, unless we go back to this whole issue of it could be a violation of federal law, but it's not a violation of state law, which NDOW can't enforce. So we need that uniformity. So maybe we could look at adding that. And then on the private property under C, is that clearly marked private property? Because that, you know, it could be someone that has a lot of acreage that, you know, butts up against a trail and people don't know, you know, that they've even passed on to, I mean, I don't know how that works out on big sets of land or something where there's residences, you know, that could be large residences. And I'm still really concerned about a lot of these other issues that we've looked at this week. You know, now that we've limited it down to residences, you know, I have great concern about making sure that we address a lot of these issues, and I'm not sure if I should say that for public comment, but I do believe that trapping is in direct conflict with what the majority of people in Clark County want and need, not only for public safety, but for just that, you know, public perception. You know, a lot's happened in the past few weeks that have made people a lot more aware that trapping is going on in Clark County. To be honest with you, before I started attending these meetings, I had no idea. I really didn't. You know, you don't think that it's happening right there off the road, the side of the road, or, you know, and you heard testimony last night from the folks at Mount Charleston, and it's happening. You can actually see the traps, you know, that are there. So, and I'll just say that and say, I guess, reserve the rest. Are we going to get to public comment, or should I just say what I want to say now? Because
We'll get to it.
Okay. Thank you.
Paul Dixon. For the record, Paul Dixon, Clark County. I wanted to thank Commissioner McNinch and you, Mr. Robb, Commissioner Drew, for your meeting last night. When Assemblywoman Maggie Carlton came to my CAB meeting and specifically told us that we should focus on the word residence. We should make a rule that was not too expansive or too narrow in the definition around residence and standoff from residence. What you put together, I think, is a valiant and very hard-fought piece of work. I congratulate you guys for it. I think you've held true to what she felt on the Natural Resources Committee, her expectations for Senate Bill 226. So I want to say thank you, and I think you guys have held to what we were asked to do. And I know there's work that we want to do after this, and we should do after this, as you said, Commissioner McNinch, to fill in some of the other questions that have been asked by people. And I would have expectations that your committee will continue to work on those and address those as we go to the future. So thank you. Stacy Newman.
Stacia Newman with Nevada Political Action for Animals. I just wanted to mention really quickly is that even though our population here in Clark County is 2 million, we have millions upon millions of people that come in to visit in our city, and the 2 million that are already here, plus millions of people that visit here, all go to Mount Charleston at some time or another to enjoy the snow, to sightsee, and now Mount Charleston is about to expand. So I think that based upon all the people that come here, we have no control over them. I was hoping that you would consider the no firearm area as kind of the boundaries, because we have no way to control the people that come in here. And especially, you know, there's mentioned Red Rock. That's another issue, is that just an isolated area. as referred to in here, the people travel all over. They'll get out of their cars, they'll walk. Even a half a mile is nothing to people that get out and walk. Hikers, casual people that just come out, campers, children especially. So I think that we have to really stay focused on where the injury will happen. So far, there's been no incidences, I guess, of people getting caught in the traps or children, but that's not going to say that it won't happen. And I think our first responsibility here would be to the people. And with the traps being set really close to a lot, many residences, and the lots are large in some cases, so, just isolating it to dwelling or to structure, I think we should really consider taking that back to the no firearm area, because that would cover a little bit larger area where people are going to travel. And I think that, for the public safety, the general public, and believe me, I've been here 14 years, and they are shocked to hear that trapping goes on. They think it's a thing of the past, but it's not. And I hear this over and over again. And probably before long, the real estate board will have to make another disclosure in addition to scorpions and all the other things that we have to disclose on a regular basis. Is it now trapping? So unless we want to take on, a real responsible way and say we're going to post signs everywhere to say that you're entering into a trapping area as a disclosure item to people that know that there may be a risk of harm there. So I think unless we, act now, that this board may be in failure of protecting the public. So, and now even in direction that if someone gets hurt, especially a child or a person, we're setting ourselves up for a liability lawsuit, where you already have prior knowledge that there is a risk there. You're not acting on it fully to protect the public. So I would say in closing, Mount Charleston would have to be considered, and the entire area of Red Rock for the safety of the public. Thank you.
Thank you.
Joe Blakesley.
Joe Blakesley, President of the Nevada Trappers Association. The one thing that I would like to say is I don't want to expand on the product that we have right now. We've got a timeline that we need to accomplish a mandate from the legislature, and I think that we can probably fine-tune what's on the product that we have at hand. These other things can be dealt with at another time, but let's get on with what we're supposed to do, deal with that. I have a couple of issues on that product. The 1,000 feet, 1,000-yard thing is one. May have to talk a little bit more about the waterways, but other than that, let's confine it to that for now and get this thing done, because the time we have to get this to LCB, get it into a permanent regulation before the season starts, and most importantly, before the end of the year, which is what SB 226 says we have to do. We don't have a lot of time to dawdle around. So that's my main focus, is the timeline. Thank you.
Aaron Lane. And you're speaking on behalf of the group, so you mark your card 3 minutes. So.
Karen Lane, Las Vegas Valley Humane Society. We do need to get going with this. I totally agree. But we also need to talk about some of the issues that have been discussed here today, particularly because we do have federal land that a lot of this trapping is going on, and there are issues that I think that need to be addressed. I hope that I hope that the residents deals with Mount Charleston. I definitely think those people need relief, and I think that we have to address those issues. I mean, there are some very big issues there. But you know what? What I see right now is a small group of trappers in a very large city, and I think we're trying to reach some consensus. I'm not convinced we've done it here. I agree we need to move forward, but there are other issues, like the visitation, that I hope that this commission will address before the next legislative session. I hope that you do that, and to look at some of these other areas and not expect the outside groups to come in, go to the legislature, and we play this ping pong game that we've done with SB 226. Thank you.
That's all the cards I have.
Okay, anybody else in the public want to make any public comment with regard to this agenda item on trapping? Okay, seeing none, I'll bring it back to the commission. This is, I think, possible action, right?
Yeah, and then- okay, and as such, I guess the committee's, looking for, well, I mean, we need to know what's on everybody's mind. Does the board have any questions specific to what we propose, so we can make sure that we're all on the same page with at least what's in front of us, and we can start there.
I think in general, there are a lot of issues that have not been dealt with in this regulation, or a number of them. Some of them that we can't deal with as we got information from the DAG, but also we have to stay on. We have to stay focused, and it became very apparent to me that the divide between the two groups is going to require that we spend more time than we have, and so therefore we need to stay focused on this regulation. And but it's my hope that the committee will continue on after that. But yeah, I think we need to keep moving.
Okay, so, question? Me? For the committee? Nothing specific. Okay.
Okay.
Later.
He's holding back.
Okay. I guess
Mañana.
with lack of direction at this point in time, the Mount Charleston it's definitely, did we miss the boat on it? I'll concede that we underestimated it a little bit. I've said that on the record last night. I'll say it again. And, we have, there's no excuses. Bottom line is, there's certainly issues there that need to be addressed. Is handling it through this exact process right this minute, that's something that we need to decide probably today. If the board feels that it's important that we need to move forward in that arena, then we need to take action to direct the committee to go ahead and get into that area. It's not something that we've specifically addressed. When Rob and I put this together, we thought we had a lot of those issues, not all of them, but we certainly were under the impression that we had at least the residential issue, the areas covered, and that would resolve some of the concerns in those particular areas. The trails were the big deal, the big issue. So,
I guess my response is that yes, we've probably haven't gone far enough, but I can tell you that in the discussions that I've had with parties on both sides, we're ways from getting that all figured out, and it's a very complex issue, and there's other laws out there that we need to be, get a better handle on as to their impact on this issue, and the overriding thing that we need to stay focused on is getting the portion of getting SB 226 finished, and so ultimately, SB 226 was drafted very specifically, and this regulation is dealing with that. And so, yes, we probably have the authority to go beyond it, but if we do that, I am very concerned that we will miss our deadline. We'll get bogged down on all these other issues. So I think we, need to stay away from that for now. But as soon as, we get through this process with SB 226, I think we owe it to the residents of Clark County and the residents specifically up at Mount Charleston, and to maybe a lesser extent in Red Rock, to get those issues dealt with. Something along the lines, definitely on the trails. We've done something similar up in Washoe, and so I think, following a path there, but there's all the other issues on roads and whatnot. So, yeah, we definitely need to deal with it. We just can't do it now.
good.
I'll just reiterate a comment that I made last night, and that is that We've got to keep in mind that the regulation we're drafting pertains to 2 entire counties with some very different issues. And so I don't think it's an oversight by the committee that Charleston specifically isn't addressed here. I just don't think it's the right mechanism in this regulation. So I think there's better ways of getting to those specific issues for Mount Charleston and Lee Canyon and some of those areas. And we've done some of that in the north already. So I agree that those are things we need to work on. I don't think this is the mechanism right now. I think this is kind of our first step in a multi-step process. So don't, just because it's not specific enough for those items in here, remember we're dealing with an issue that's very broad across 2 entire counties. So that's just kind of my general thought there.
Commissioner Rob?
Last night after the meeting adjourned, I had some conversations, Tom Padden being one of them. I sat down with a map. We're talking about Lee Canyon and Mount Charleston area. I wasn't aware of the subdivisions up there. With the subdivisions and residential areas up there, with the language that we have in that we've been talking about, setbacks from residents, it will pretty much cover a great deal of those areas, with the exception of maybe a few trails. So I think the regulations we're looking at, with my new understanding of the map, after I sat down with a few people after the meeting, I think we can get one heck of a lot closer than you guys think with my new understanding of the map. I have committed to working with Mr. Tom Padden. He's going to look for some maps. I've committed to looking for some maps myself, and I believe that we are closer than we think. It's just with open meeting law, the communication between the 3 of us, the uptake only happens during meetings. I'm committed to this process, and if we need to speed this process up to make sure that we don't miss anything, I'm committed to doing telephonic meetings every once in a while. Even if we have to have more meetings, do something, I don't know what the answer is, but I just don't want to come up short and have the legislature tell us we came up short. I understand what you guys are saying. This might not be the right form, but I don't know if the legislature will see it as this wasn't the right form. I think they've given us one. They expect us to do it, and I will do everything I can to make sure we hit the mark.
Okay. Any other comments from the commission? Okay.
I'll just say that the intent of the committee is to meet one more time in Reno. That'll make a couple meetings in each venue, each area, and bring a proposed regulation to the commission at that time, at that March meeting in Reno for consideration and adoption, so we can get the SB 226 issues wrapped up. With the understanding that there's going to be, I'm sure, some parking lot issues and that have been identified, and we'll continue with those. That's the initial thought process. So that's my understanding of where we're headed. So.
Okay, so no motions is basically what I'm hearing then at this point in time?
No, the committee's been asked to, we assigned staff one real easy thing. They should be able to handle that relatively easily, and I don't think that we need anything else. We can continue to work on Red Rock and this Mount Charleston issue, even as a parallel path at this point in time, just to better understand what we're dealing with up there, and maybe develop some ways of handling it.
Okay. And with that, we'll conclude that agenda item, and we'll move on. We have, at this point, item 25, informational items, and unfortunately, we're running out of time. And but I think probably wouldn't be a bad idea to do the first one, 25A.
It's going to be very, very quick.
Okay, so why don't we let me just introduce it. 25A, Bear Committee report. Commissioner McNinch. Commissioner McNinch will report on the Bear Committee meeting held in Reno.
We had some crossed wires from getting our committee put in place, and the agenda. Timeframes are being what they are. The agenda went out, and to be quite frank, I read the agenda and did not notice that. So we did not have a meeting. The committee has been assigned, and the intent is between now and March to sit down with that committee and have an initial sit down, and I'll develop an agenda for that, and we'll get moving on. So at this point, there's nothing to report, but we will be meeting prior to the March meeting in Reno.
Okay. Good. Okay, well, then, I guess procedurally, do we need to do a motion to move all these to the next meeting, or what's the normal process?
Please.
Okay. So we have items 25, well, we have two Bs. I don't know how that happened, but B on the Sage-Grouse update, the WAFLA conference discussion, we were going to have a wild horse update, litigation. The committee assignments have gone out. There's nothing to talk about there at this point. And do we need to talk anything about the future agenda? No. Okay, so the only thing we have to do is public comment. So I guess maybe looking for a motion to just move all these other informational items to March.
So moved. So moved.
So moved? Okay. You have a second?
Second.
Second. Okay, I have a motion and a second to move all these informational items to March. Everybody understand the motion? Okay. I'll call for a vote. All in favor, say aye. Aye. All opposed? Motion passes. Okay, moving on. Agenda item number 28, public comment period. Persons wishing to speak on items not on the agenda should complete a speaker's card and present it to the recording secretary. Public comment will be limited to 3 minutes. No action can be taken by the commission at this time. Any item requiring commission action may be scheduled for a future commission agenda. In addition to this public comment period, public comment limited to 3 minutes per speaker will also be allowed for each agenda item, but not on reports or informational items. So I'll go ahead and open it up for public comment.
At this time, I have cards that say all. I do not have any say the public comment, so
Now's your time.
I'm sure Gina's ready.
Gina?
For the record, Gina Greisen, Nevada Voters for Animals. Again, I want to thank the Board of Commissioners and the committee chair, McNinch. It is a long, drawn-out process. Obviously, we're here to stay, and we'll just keep heading down this road together and hopefully, come closer on some of these issues. But I did want to reiterate that I think it speaks volumes that we've had this meeting today and yesterday, and the committee meeting last night in conjunction with the Sportsman's Expo. I can understand wanting to, it's easy to combine the two together, but I think it would have been a lot better to have the meeting off-site, maybe somewhere where I wouldn't have had to pay for parking and that people wouldn't have been so intimidated, because we had a lot of folks that just weren't going to come here. There are very specific people that should be here today speaking directly to these issues that are not here because it was held here. So I want to say that, and I want to talk about the diversity of the commission itself. You can look around and see that there's a whole lot of the same kind of people on this, that don't necessarily represent, the majority of Nevadans. And the wildlife belongs to all of us. And, we don't feel, and you were at the meeting when we had the cards that say, you don't speak for me, because we have 4 trappers on our cab. That's the majority of the cab. And I know that the chair tries really hard, Paul Dixon, to, run those meetings and be fair and give everyone their chance. But the fact is that we can just talk to her blue in the face, and we know what the ultimate answer is going to be, and he's outvoted anyway. So, how far are we really going to get, to really have public input? And NDOW's own website, I quoted it the other night, says Nevada's, the wildlife of Nevada belongs to everybody. Come put your comment, your public input, show up to a meeting. We do. Doesn't get us very far, but we do, and we'll keep coming. But I wanted to talk a little bit about, obviously, this video. I have to trust the folks that are on these boards. I have to work within the limits that I have. And we know who shot the video. We know everyone knows about the video. But I want to talk about the difference between a sportsman, a hunter that tracks, goes and shoots. We sat here all day and talked about the limits on what hunters can shoot. All day long we were here. How many you can have? You have to have a tag. There's pages and pages of rules for the hunters, but there's very few rules for the trappers. The hunters have a duty to pursue. It's in
15 seconds.
your book, okay? Not trappers. They have 96 hours and it's a common violation. There are limits on what you can get, not for the trappers. You have to eat the meat. It says it's unlawful to waste game for the hunters, not the trappers. They can't eat skunks or whatever else, coyotes.
Wrap it up.
You guys go after a specific animal, trappers set a trap, and they don't even know what they're going to get. There's a big difference here. I know that there are many sportsmen that are very disappointed in what has been going on, and trapping, obviously, is hugely on the radar. So, thank you.
Okay, thanks, Gina. Okay, yeah, anybody else from the public, non-public comment? Okay. Then I will call for our meeting to be adjourned. Yeah. Second? Okay, done, thank you.
OJ quadruplets coming up. Do not put your boarding passes
What's refreshing about it?
Two bits. Okay. Okay. No, seriously. I've got my notes right here. All right.
Better you than me, man.
Me.